A sloth, a donkey, and a curious human. Send a prompt and see what they're doing. One hits record with a question on his mind. Two brothers pick it up, see what they find. Corn takes his time, Herman's got the facts. Back and forth, they never hold back. My weird prompts, come on in, that's where we begin. My weird prompts, glad you're here.
This episode was generated using artificial intelligence. Please verify facts.
My Weird Prompts is a community-driven initiative exploring how AI can fuel curiosity and uncover the fascinating ways our world works. GPU compute for this podcast is generously provided by Modal. Learn more at modal.com.
You know, Herman, I was looking at my mail this morning, and it occurred to me that I can send a postcard from here to a tiny remote village in the Andes Mountains, and it will actually get there. It might take a few weeks, but the system works. Yet, if the International Court of Justice tells a country to stop a war or provide food to a starving population, everyone just kind of looks at their watches and waits for the next news cycle. It is a bizarre paradox. We have mastered the art of moving paper across the globe, but we cannot seem to move the needle on human suffering when the big powers are involved.
I'm Herman Poppleberry, and that is a fascinating place to start because it highlights the two completely different worlds of international law that exist simultaneously as of March 26, 2026. On one hand, you have the performative, high-stakes drama we see in The Hague, which often feels like a theater of the absurd. On the other hand, you have the functional, technical infrastructure that actually keeps the world from descending into total chaos. Today's prompt from Daniel is about this exact divide, the massive legitimacy crisis in the high-profile stuff, and why the system seems to be failing at the big things while quietly succeeding at the small ones.
It feels like we are living in a world where the law is either a blunt instrument used for political theater or a set of invisible tracks that nobody notices until a train derails. Daniel mentioned that the International Court of Justice, or the ICJ, has 24 active cases right now. That is a 20-year high. On paper, the court has never been busier. But Herman, is being busy the same as being effective? If the docket is full but the tanks are still rolling, what are we actually accomplishing?
That is the multi-billion-dollar question. The data suggests a massive enforcement gap that is becoming impossible to ignore. Look at the International Criminal Court, the ICC. Just a few weeks ago, on March 5th, Prosecutor Karim Khan gave an update to the Assembly of States parties. He basically had to admit that arrest warrants issued back in 2024 and 2025 are still just sitting there, gathering dust. Several member states are simply refusing to execute them. When you have 124 countries signed up to the Rome Statute, but the big players like the United States, Russia, China, and Israel stay out of it, the jurisdictional map looks like Swiss cheese. It is a court with a long reach but no hands to grab anyone.
It is like being invited to a club where the bouncer only checks the IDs of the people who were already planning to follow the rules. And if you are a permanent member of the Security Council, you basically have a get-out-of-jail-free card in your back pocket. Daniel pointed out that the P5, the permanent members, have used the veto 12 times in just the last 24 months. That is once every 2 months. It is less of a Security Council and more of a security stalemate.
The paralysis of Article 94 is the core of the issue. Under the United Nations Charter, the Security Council is the only body that can actually enforce a ruling from the International Court of Justice. But if you are one of the permanent 5, or even just a close ally of one, you know that no matter what the judges say, the enforcement mechanism is dead on arrival. This is why we see things like the supplemental order from March 12th regarding the situation in Gaza. The court mandated the unhindered provision of basic services to address what they called imminent famine. It was a powerful statement, a legal mandate, but without the Security Council acting as the bailiff, those mandates are essentially moral suggestions.
Moral suggestions with very expensive legal teams. I want to dig into how this looks from the Israeli perspective, because Daniel brought up a term that always gets people fired up, lawfare. It sounds like something a lawyer came up with while playing too much Call of Duty. But the argument from guys like Tal Becker, the legal advisor to the Ministry of Foreign Affairs in Israel, is that international law is being weaponized. He argues it is not about justice anymore. It is about using the court as a PR firm with gavels to delegitimize a state's right to self-defense.
Tal Becker's argument is actually quite technical, even if the term lawfare sounds cinematic. It centers on the distortion of what we call customary international law, or CIL. In theory, for something to become international law without a formal treaty, you need two things. You need the general and consistent practice of states, and you need opinio juris, that is, O-P-N-E-O-Y-O-O. Y-O-O, ris, which is the belief by those states that they are legally obligated to act that way. The friction arises because critics and certain international bodies are trying to shortcut that process.
Right. They are trying to turn a non-binding United Nations General Assembly resolution into a binding law just by repeating it enough times. It is like if I told you every single day that you owe me $5. Eventually, I might start claiming it as a customary debt, but that does not mean you ever agreed to the contract. You never signed anything, and you certainly do not feel a legal obligation to pay me.
That is a very accurate way to frame the Israeli critique. The argument is that the General Assembly, which is a political body, not a legal one, is being used to manufacture a consensus where none actually exists. If you can convince a court to treat a non-binding resolution as evidence of customary law, you have effectively bypassed the need for a state to actually consent to a treaty. For a country like Israel, which views its security through the lens of sovereign survival, this looks less like the rule of law and more like a tactical encirclement by legal jargon. They feel they are being judged by rules they never agreed to, interpreted by people who are politically motivated.
And it is not just Israel feeling this way. Daniel pointed out that we are seeing a massive legitimacy crisis with the International Court of Justice more broadly. We have Global South nations threatening to withdraw from the optional clause. For those of us who do not spend our weekends reading the ICJ handbook, what is the optional clause, and why is it currently a ticking time bomb as we sit here in March 2026?
The optional clause, or Article 36, paragraph 2 of the statute, is what gives the court compulsory jurisdiction. Basically, a country agrees in advance that if another country sues them, they will show up and accept the ruling as binding. It is a huge leap of faith. If you withdraw from that, you are essentially saying you will only play ball if you feel like it on a case-by-case basis. The reason we are seeing this threat from the Global South is a perceived Western bias. They see the court moving with lightning speed on some issues, like Ukraine, while dragging its feet for decades on others. They are starting to view the whole Hague ecosystem as a tool of neo-colonialism, where the law is only universal, when it suits the interests of the powerful.
So the Western powers think the court is being weaponized against them by the General Assembly, and the Global South thinks the court is a Western tool used to keep them in line. It sounds like everyone is unhappy, which usually means the system is either perfectly balanced or completely broken. Given that the enforcement is non-existent, I am leaning toward broken. We covered some of this back in episode 614 when we looked at those international arrest warrants, but the gap between the paper and the pavement has only grown since then.
It leads to what scholars call fragmentation. When the universal system fails, countries do not just stop having laws, they start making their own regional ones. We see the European Union or the African Union developing their own enforcement standards because they have lost faith in the United Nations framework. But Korn, this is where we have to pivot, because if we only look at the headlines about war crimes and vetoes, we miss the part of international law that actually works perfectly every single day.
You mean the boring stuff? The stuff that does not involve generals in dress uniforms or judges in silk robes? The plumbing of the world?
Consider the International Civil Aviation Organization, or the ICAO. They manage the Chicago Convention. Every single day, over 100,000 commercial flights take off and land. They cross borders, they use standardized radio frequencies, they follow the same safety protocols, and they use the same English language aviation terminology. There is near total compliance. Why? Is it because they love international law?
No, it is because if you do not comply, your planes crash, or you are not allowed to land anywhere. It is self-interest masquerading as legal obedience. If a pilot decides to ignore the ICAO's rules on altitude or transponder codes, the law of gravity is going to enforce itself a lot faster than the Security Council ever could. If you do not follow the rules, you are out of the game.
The functional consensus is driven by technical necessity. The International Telecommunication Union, the ITU, is another perfect example. They manage the global radio spectrum and satellite orbits. If a country decides to go rogue and jam frequencies or ignore satellite slots, they end up hurting their own communications as much as everyone else's. It is a system of immediate self-defeating chaos if you break the rules. You cannot have a sovereign radio frequency that overlaps with your neighbors without both of you losing the ability to broadcast. So, everyone agrees to the rules because the alternative is total silence.
So, international law works when it is about plumbing, but fails when it is about architecture. We can agree on how the pipe should connect because we all want running water, but we cannot agree on what the building should look like or who gets to live in the penthouse. Daniel's prompt asks what the purpose of a legal system is when it is viewed as unfair and poorly enforced. If the ICJ is just a place for countries to yell at each other in expensive suits while people are dying, is it doing more harm than good? Is it just providing a veneer of legitimacy to a world that is actually ruled by force?
There is a school of thought that says the performative side of international law acts as a safety valve. It provides a forum for grievances that might otherwise turn into immediate kinetic conflict. Even if the rulings are not enforced, the process of litigation can delay escalation. It forces states to frame their arguments in the language of rules rather than the language of threats. But the danger, as we are seeing in March 2026, is that when the gap between the court's rhetoric and the reality on the ground becomes too wide, it breeds a deep, corrosive cynicism.
Cynicism is the polite word for it. If I am a civilian in a conflict zone, and I hear that a court in the Netherlands has issued a supplemental order for my protection, but the bombs are still falling, and the food trucks are still blocked, I am not going to have much respect for the rule of law. I am going to see it as a cruel joke played by elites in a safe city. And on the flip side, if I am a soldier or a policymaker, and I feel like the law is being twisted and weaponized to prevent me from defending my country against an existential threat, I am going to start viewing international institutions as hostile actors. I am going to stop listening entirely.
That is the lawfare trap. When law becomes a weapon, it loses its status as a neutral arbiter. If the goal of a legal filing is to win a news cycle or trigger a social media campaign rather than to settle a dispute, the court becomes just another theater of war. This is why the distinction Daniel makes is so vital. We have to separate the geopolitical litigation from the functional infrastructure. The Universal Postal Union, with 192 member countries, ensures that mail moves across borders seamlessly. That is international law working at its peak. It is a treaty from 1874 that still functions because everyone wants their mail delivered, but nobody writes a headline about a letter being delivered on time.
Maybe we should. Local man receives bill from utility company, thanks to international treaty. It does not have the same ring to it as war crimes investigation opened, but it is arguably more relevant to the daily survival of global civilization. I think the takeaway for people following this is that we're witnessing the death of the global government myth. International law was never meant to be a world police force. It is a series of contracts between sovereign states.
And those contracts only work when there is a shared, tangible benefit to following them. Sovereignty is not a bug in the system, it is the fundamental feature. The enforcement gap exists because states are not willing to give up their ultimate power to a central authority. When we see the United States or Russia use a veto, they are not breaking the system. They are using the system exactly as it was designed in 1945 to protect their own national interests. The founders of the United Nations knew that if they tried to force the big powers to do things they did not want to do, the whole organization would collapse. The veto was the price of admission.
It is a design that was built for a post-World War II reality that feels increasingly disconnected from 2026. If the system relies entirely on the consent of the powerful, then the law only applies to the weak. That is a hard pill to swallow if you believe in the idea of universal justice. But if you look at it as a tool for coordination, like the ICAO or the ITU, it is actually incredibly successful. It is a coordination mechanism, not a moral authority.
We should probably talk about what happens next. If the ICJ continues to lose legitimacy and we see more withdrawals from the optional clause, do we end up in a world of total lawlessness? Or do we just move toward a more honest version of international relations where we admit that some things are legal and some things are just power politics?
I suspect we see a shift toward bilateral or small group agreements. Instead of one big broken court, you have a bunch of smaller functional ones where the members actually have skin in the game. It is the fragmentation you mentioned. The big universal dreams of the 20th century are being replaced by the practical regional realities of the 21st. We talked about some of this legal labyrinth back in episode 1302 when we looked at disputed territories, and it seems the labyrinth is only getting more complex and more divided.
The risk of fragmentation is that it creates a world of competing standards. If the European Union has one set of human rights enforcement and the African Union has another, and the Shanghai Cooperation Organization has a third, then international law as a singular concept ceases to exist. We return to a world of regional blocks. This might be more stable in some ways because the people in those blocks actually agree with each other, but it makes global challenges like climate change or pandemic response much harder to coordinate. You cannot fix a global atmosphere with regional rules.
It is the difference between a global internet and a series of national intranets. We lose the connectivity, but we gain a bit of local control. It seems like the legitimacy crisis Daniel mentioned is really just a reality check. We are realizing that you cannot litigate your way to global peace if the people with the guns do not agree with the verdict. The court can say, stop, but if the Security Council says, keep going, the court's voice is just a whisper in a hurricane.
There is also the issue of what this does to the domestic politics of these countries. In Israel, the constant pressure from international courts has arguably hardened public opinion against international institutions. When people feel unfairly targeted by what they see as lawfare, they do not usually respond by saying, you know what, those judges in The Hague have a point. They respond by circling the wagons. They become more nationalist, more defiant.
It is the same in the United States. Whenever an international body tries to weigh in on American policy, the immediate reaction from a large part of the population is to tell them to mind their own business. It creates a political incentive for leaders to be defiant. Being wanted by an international court can actually be a domestic polling boost in some parts of the world. It turns a politician into a martyr for national sovereignty.
That is a perverse incentive structure for a legal system. If the goal of the law is to deter certain behaviors, but the process of the law actually encourages those behaviors by boosting a leader's popularity, the system is actively working against its own stated goals. This is why the functional, technical side is so much more successful. There is no glory in defying the Universal Postal Union. You do not look like a hero of sovereignty, you just look like an idiot who cannot get his mail delivered. There is no political upside to breaking the rules of the International Telecommunication Union.
I think that is the key. We need more boring law and less spectacle law. But the spectacle is what gets the funding, the media attention, and the prestige. Nobody wants to be the world's most famous postal lawyer. They want to be the prosecutor who takes down a head of state, even if that head of state is never actually going to see the inside of a courtroom. The professional incentives are all skewed toward the high drama, low impact stuff.
It is a matter of social capital within the international legal community. There is a lot of prestige in being part of the high-profile litigation world. But as we see with the ICJ docket being at a 20-year high, the quantity of litigation is not translating into a quality of peace. In fact, you could argue that the more we litigate these deep-seated historical and religious conflicts, the more we entrench the divisions. We are trying to use a hammer to fix a computer.
So, for the person listening to this who sees a headline tomorrow about another ICJ ruling or an ICC warrant, what should their internal filter be? How do they distinguish between the noise and the signal in this fragmented world of March 2026?
The first question should always be, who is the enforcement mechanism? If the answer is the United Nations Security Council, you can almost guarantee that if a major power or its ally is involved, nothing will happen on the ground. The second question is, does this rely on a formal treaty that the parties actually signed and ratified, or is it based on this fuzzy, evolving concept of customary international law? If it is the latter, you are likely looking at lawfare, a political struggle dressed up in legal robes.
And if the headline is about a new agreement on satellite orbits, cross-border banking protocols, or aviation safety, that is the signal. That is the part of the world that is actually being governed. It is not as exciting as a war crimes trial. But it is the reason your phone works, your bank account is still there, and your flight home is not going to collide with another plane.
We have to appreciate the miracle of the functional systems. The fact that 192 countries, many of whom hate each other, can agree on how to handle a stamped envelope is actually a massive achievement of human civilization. We just take it for granted because it works. We only notice the law when it fails, which is why we have this skewed perception that international law is a total disaster. It is a disaster in the headlines, but a triumph in the background.
It is like an IT department. If they are doing their job, you do not even know they exist. You only call them when the server is down and you want to scream at someone. International law is currently in a state where the servers for the Global Peace app are permanently down, but the mail delivery and aviation safety apps are running with 99.9% uptime. We are screaming at the IT guys about the Peace app while ignoring the fact that the rest of the building still has electricity.
That is a very apt comparison. And the problem is that we are trying to fix the Global Peace app by hiring more lawyers and issuing more press releases, when the issue is actually with the hardware. The hardware being the reality of state sovereignty and the lack of a global monopoly on force. Until someone is willing to build a world government with a world army, which nobody actually wants, international law will always be a voluntary system for the powerful.
Which brings us back to Daniel's question about the purpose of a system that is viewed as unfair. Maybe the purpose isn't justice in the way we think of it in a domestic courtroom. Maybe the purpose is just to provide a framework for negotiation. It is a way for countries to talk to each other using a common vocabulary, even if they disagree on the definitions of the words. It keeps the conversation going, which is usually better than the alternative.
It is a language of diplomacy. When a country like Israel sends a top-tier legal team to argue about customary international law, they are engaging with the system. They are saying, we care about these rules enough to argue about their interpretation. That is a far cry from a world where countries just ignore the concept of law entirely and do whatever they want without any justification. Even the act of arguing is a form of compliance.
Even the hypocrisy is a kind of tribute to the law. When a country violates a norm and then spends millions of dollars on lawyers to explain why they didn't actually violate it, they are acknowledging that the norm matters. If the law were truly dead, they wouldn't bother with the excuses. They would just do it and stay silent.
That is the civilizing influence of international law, even in its most broken state. It forces power to justify itself. It might be a thin shield and it might be full of holes, but it is better than no shield at all. The challenge for the next decade is whether we can preserve the functional, technical parts of the system while the geopolitical parts continue to crumble under the weight of their own contradictions. We cannot let the failure of the Peace app crash the aviation app.
Well, I, for one, am going to go write a letter and marvel at the fact that it will actually reach its destination. It is the little victories that keep you going. Daniel, thanks for the prompt. This was a deep one, and I think it is going to make me look at the news from The Hague with a lot more skepticism, and the news from the Postal Union with a lot more respect.
It is a necessary shift in perspective. We have to stop expecting the ICJ to be the Supreme Court of the world and start appreciating the technical treaties for the silent, essential work they do every day. If we can do that, the legitimacy crisis looks less like an apocalypse and more like a long overdue recalibration of our expectations.
Before we wrap up, a big thanks to our producer, Hilbert Flumingtop, for keeping the gears turning behind the scenes. And of course, a huge shout out to Modolf for providing the GPU credits that power this show and allow us to dive into these complex topics every week.
This has been My Weird Prompts. If you are finding these deep dives helpful for navigating the chaos of 2026, consider leaving us a review on your favorite podcast app. It really does help other curious minds find the show.
Find us at myweirdprompts.com for the full archive and all the ways to subscribe. We will be back soon with whatever weirdness Daniel sends our way next.
Stay curious.
And keep an eye on your mail. It is a miracle it even gets there. Goodbye.
Goodbye.
This episode was generated using Gemini Flash 3. Text-to-speech engine was Chatterbox.
Thanks for listening to our show, My Weird Prompts.